consent to search his vehicle, and the canine unit sniffed the vehicle and did not alert. After Mr. Miles admits to using marijuana for his back problems, the officers thoroughly search his vehicle, including the contents of notebooks, folders, and other containers, and do not find any illegal substances. As we have discussed in previous episodes of ATA, the Supreme Court held in the 1983 case of United States v. Place that a canine sniff does not constitute a quote-unquote search for Fourth Amendment purposes. And in the 2005 case of Illinois v. Caballes, the court determined that, quote, a dog sniff conducted during a lawful traffic stop that reveals no information other than the location of a substance that no individual has any right to possess does not violate the Fourth Amendment. However, the Supreme Court clarified in the 2015 case of Rodriguez v. United States that officers cannot extend a traffic stop beyond the time needed to handle the matter for which the stop was made to conduct a dog sniff without independent, reasonable, articulable suspicion of additional criminal activity. This situation is more complex than the typical traffic stop, as there are serious questions about the legality of the underlying stop and Mr. Miles' apparent arrest. And the issue is further complicated by the fact that the officers failed to request emergency medical services until after the sniff was completed, although they seem to be waiting for EMS to arrive before taking Mr. Miles into custody when the canine unit arrived. Still, Mr. Miles would potentially have an argument that his roadside seizure was unlawfully extended to allow for the canine to sniff his vehicle. Additionally, while the legal issues surrounding the dog sniff are murky, it is far more likely that the court would determine that the officer's extensive search of Mr. Miles' vehicle violated the Fourth Amendment. Although officers are generally required to obtain a warrant before searching a vehicle, courts have recognized several exceptions to this rule under which warrantless vehicle searches are considered constitutionally reasonable. For instance, as the Supreme Court explained in the 1996 case of Pennsylvania v. LeBron, quote, if a car is readily mobile and probable cause exists to believe it contains contraband, the Fourth Amendment permits police to search the vehicle. Although the Fourth Circuit Court of Appeals held in the 2002 case of U.S. v. Sheets that the odor of marijuana gives officers probable cause to search a vehicle, there is no precedent suggesting that a driver's admission to general marijuana use allows officers to search their vehicle. And in this situation, it is likely that a court would conclude that the officers did not have probable cause to search Mr. Miles' vehicle based on his admission to using marijuana, absent any evidence tying that use to the vehicle, particularly given the fact that a canine unit had sniffed the vehicle and failed to detect any illegal substances. Other exceptions to the warrant requirement include inventory searches when a vehicle is being impounded, and searches incident to arrest, which, as the Supreme Court explained in the 2011 case of Davis v. United States, is limited to situations where, now quoting, the arrestee is within reaching distance of the vehicle during the search, or if the police have reason to believe that the vehicle contains evidence relevant to the crime of arrest. A court would almost certainly conclude that these exceptions did not apply because the vehicle was not being impounded, Mr. Miles was nowhere near the vehicle, and the officers did not appear to have probable cause that any evidence was in the vehicle, having already determined that the package was still on the porch.
That medicine bottle right there also belongs to him. I didn't do the trunk yet.
Yeah, I think the city wants to leave it alone.
Okay.
Stop! Stop making Amazon sellers